if we go down this road, how much will your utility bill go up? How much gas prices will go up? We need to actually talk more honestly about that.
If we spend $50 trillion, or however much it takes, to make the United States carbon neutral by 2050, how much will it lower world temperatures?
Senator, that depends on the rest of the world.
Do you
to create harmonized incentives to reduce
Do you believe
emissions.
in the tooth fairy?
No, sir.
Do you believe in the Easter Bunny?
No, sir.
Do you believe that Jimmy Hoffa died of natural causes? No.
Deloitte predicts the differential between being responsible and reckless about climate could sum to more than $220 trillion globally between now and 2070. This is just the beginning. It will certainly get worse, much worse, particularly if warming exceeds 1.5 degrees. We are on a bad trajectory. It's time for us all to wake up and face the problem before coastal cities flood with water or Southwest cities can't get water. Alito came before this committee, and he had the chance to tell us that he thought Roe was egregiously wrong, make that observation about that case, and instead he hid that sentiment. He said instead,
Roe versus Wade is an important precedent of the Supreme Court. It was decided in 1973, so it's been on the books for a long time. It has been challenged on a number of occasions, and I discussed those yesterday, and the Supreme Court has reaffirmed the decision.
So looking back, he looks a lot like a sleeper agent predetermined to attack Roe, who wouldn't disclose what he was up to until he had the majority that he needed to change the legal standard and destroy the legal precedent.
Packing the court destroys the court.
Since 2020, we've seen proposals to resurrect the failed, misguided idea of court packing.
There has been considerable debate about the efforts of the radical left and the Democrat Party to pack the United States Supreme Court.
My sense is the court has already been packed. It has been packed as the result of a very long and expensive effort run by a handful of secretive right-wing billionaires through a bunch of front groups. The tally of the cost of the operation has risen from the original $250 million estimate of the Washington Post to now $580 million spent on trying to make sure that those billionaires succeeded in what has been characterized in this room as the long effort to make this a conservative court. Last year, the ocean absorbed the equivalent of 7 Hiroshima bombs detonating every second in the ocean. Every second of every day for the entire year, 7 nuclear detonations worth of heat into our oceans per second. Water temperatures in Florida have hit records reaching as high as 101 degrees. That's not the air temperature, that's the ocean temperature. That's actually the recommended temperature for a hot tub. Indeed, that's the midpoint of the jacuzzi company's recommended range for its hot tub temperatures for healthy adults. Now, doctors recommend that children under the age of 5 avoid hot tubs over 95 degrees, and pregnant women are advised to stay out of water once it gets much above 100 degrees. So the ocean off Florida is almost too hot for many humans.
I met with Biden, President Biden, about 3 weeks ago when he came down to tour the damage, and I talked to him about the importance of getting FEMA fully funded. There's a federal disaster relief fund that's part of FEMA, and that pays for things like debris pickup, helps individuals that have lost their homes, helps our small businesses, a variety of things like that. Right now, this thing is getting low on funds. I checked on September 11th, it's down to $2.5 billion, and they project by the end of this month it'll be down to $550 million. What I'm asking for is a standalone vote on my bill, which is called the Federal Disaster Responsibility Act, and I hope every senator here will unanimously agree that we should do this.
May I say that I appreciate that Senator Scott would like to accelerate disaster aid to his home state, but let me observe that disasters have taken place not only in Florida, but in the presiding officer's home state of Hawaii, in Vermont, in New York, and Louisiana, and other states as well. And in response to that, what President Biden did was made a request of Congress in August to pass a comprehensive emergency supplemental that includes an increase in funding for FEMA's Disaster Relief Fund. It also includes $45 million for the Department of Ag and $15 million for the Department of Interior to support more than 20,000 firefighters who are out there braving this explosion in new wildfires that are taking place across our country. And we absolutely need to head off the root cause of all of this, which is fossil fuel emissions, choking our atmosphere with greenhouse gases, heating up the earth, and causing us to spin out from basic conditions of habitability of the earth that have existed for tens of thousands of years. The question of whether Justice Thomas should have recused himself from the January 6 cases depends on a single fact: what he knew about his wife's involvement in insurrection activities. If he knew absolutely nothing at all, okay, then it's probably okay for him to recuse himself. Maybe a little bit of appearance of impropriety, but if he actually knew of her involvement in those matters, then he absolutely should have recused himself. And the question, Justice Thomas, what did you know and when did you know it, has never been asked and never been answered. That's not a tenable way for a court that purports to represent due process and enforce due process to conduct itself with respect to conflict of interest. Almost exactly 5 years ago, I sent around this binder to all of my Senate colleagues, in which I compiled some of the most compelling warnings about the economic risks associated with climate change. Last week, I sent your staffs an updated version of the binder. Here it is. As you can see, the warnings keep piling up. Have fun with the light reading. Look at our national debt. One thing that stands out is how much of it was incurred as a result of exogenous shocks to the economy. Consider the 2008 financial crisis, which blew up the financial security of families and businesses across the country and reduced government revenues for a decade. Consider the pandemic. The Committee for a Responsible Federal Budget estimates that the federal response to the pandemic, which brought COVID under control, protected families, and jump-started our economic recovery, will add $5.5 trillion to our deficits. Plenty of epidemiologists warned that the country was woefully unprepared for a pandemic. Now, we have all these warnings. Warnings of crashes in coastal property values as rising seas and more powerful storms hit the 30-year mortgage horizon. Warnings of insurance collapse from more frequent, intense, and unpredictable wildfires. A dangerous interplay between the insurance and mortgage markets hitting real estate markets across the country. Inflation from decreased agricultural yields. Massive infrastructure demand, trouble in municipal bond markets, stranded assets, and a carbon bubble. The most dangerous risks are called systemic, meaning that they will cascade out into the broader economy as the mortgage problem did in 2008. And it's big. Some of the gravest dangers of climate change, which we could head off today, come to pass years or decades out. Rhode Island's coastline will be gone, reshaped into an archipelago by 2100, you say. Who cares? What's that? It's an eternity. Well, almost exactly a year ago, I became a grandfather for the first time. Baby Vera, God willing, will be alive in 2100. When I look at her, I'm looking at that future. Walk by any elementary school. The faces you see on the playground, God willing, will be alive in 2100. How will those little ones remember our less than greatest generation. We owe it to kids on playgrounds all across America to pay attention to get this right. By the end of this series of hearings, if we hear these expert witnesses, if we treat their testimony as our headlights, then our path, I hope, will be clear. Thank you, and let's get to work. Mr. President, this is the 289th time that I have come to the Senate floor with my increasingly battered time-to-wake-up chart to stir this chamber to act on climate change. Since 2016, I have been talking about the zettajoule. The zettajoule is the measure of how much fossil fuel emissions are heating up our oceans. In this season of extreme, record-smashing heat touching all 50 states, it is wild that elected representatives in Washington still choose to insulate themselves from reality, a reality measured in zettajoules. A zettajoule is a number almost beyond comprehension in its size. 1 joule, Joule, is our standard unit of energy, and it applies to heat energy. A zettajoule is 1 joule with 21 zeros behind it. It is a truly massive number. In a 2019 Time to Wake Up speech, I reported that more than 9 zettajoules of heat energy was being added to the ocean annually. Since then, I've come to the floor with an updated number. Our oceans are absorbing around 14 zettajoules of excess heat every year. Let's put that in context. The total energy consumption of all humankind amounts to about 1/2 of a zettajoule of energy per year. That means that for the fossil fuel component of that 1/2 of a zettajoule of energy, we pay the price of 14 added zettajoules of heat into the ocean every year. Said another way, we load into our Earth's oceans every year nearly 30 times the entire energy use of the entire species on the entire planet. That is a big magnification. If this is the zettajoules of excess heat absorbed into the oceans every year, that dot is the average annual energy consumption of the human species on the planet. For the price of the fossil fuel component of that, mankind's entire energy consumption in zettajoules, we suffer that load of heat energy going into the oceans. Almost too hot for humans means definitely too hot for many ocean creatures, particularly ocean corals. Coral reefs matter because they support 1/4 of all known marine species. Florida has the largest coral reef ecosystem in the continental United States, the 3rd largest living barrier coral reef in the world. If you don't care about creatures and only care about money, well, Florida's protected waters contribute billions of tourism dollars to the Florida economy. All of that is in jeopardy in this heat. According to NOAA, when temperatures reach 1 degree Celsius, or about 2 degrees Fahrenheit warmer than normal, corals cross what is called their bleaching threshold. That is where they turn white as they evulse the living creatures that keep them alive, and that is a step on the way to death. That is bad news, considering that temperatures around Florida have been running 5 degrees above normal. And the longer this goes on, the more trouble corals will have recovering. This is not just happening in the United States, it is worldwide. This summer, most of the oceans on planet Earth have at least a 70% chance of experiencing what are called marine heat wave conditions. The effects of marine heat waves read like biblical plagues: decreased oxygen, dead zones, fish die-offs. And then come the weather effects: droughts in some places, and increasingly deadly and dangerous storms in others, because our oceans drive our weather on this planet. We need to head off climate change at the oil spigot. That means taking on the fossil fuel industry's increasingly desperate lies and its well-funded political juggernaut that does such evil in this building. We know how to solve this problem. We just don't do it because fossil fuel fingers creep through so many corners of the Capitol. In the time it took me to deliver this speech, around 6,000 Hiroshima bombs of excess heat energy were put into our oceans. Every day, it's getting worse. We completely underestimate how bad things are going to get. Completely. Even people who care about climate change and believe that it's real and aren't in tow to the fossil fuel industry and its dark money, they still completely underestimate how bad this is going to get. And the tragedy is, it has always been preventable. Simply by moving to a productive, economically valuable, clean energy future and stopping our indulgence of fossil fuel pollution and obstruction. If what is going on with climate change heat going into our oceans is not enough to wake us up, I do not know what will. It is certainly time to wake up. I yield the floor. One of the things I noticed about the Dobbs decision was that in order to get where the justices in favor of that decision wanted to go, they had to change the legal standard from a balancing of interests to history and tradition. In a balancing of interests, one of the interests is the interest of the woman involved in the procedure. In history and tradition, you go back to ancient history, before women had rights, like the right to vote, like the right to have credit without the permission of their husband. It looked like the rights of women were being deliberately removed from the equation by the justices of the Supreme Court. And in that context, Ms. Zarowski, how did it feel to you? How did you feel that your rights, your interests were being considered as you went through the experience that you had to?
I felt I had absolutely no right to make a decision for my own body, for my own health, for the health of my child. I thought about when my grandfather was in the hospital, similarly also had sepsis, and my dad and his siblings were making the decision on how he should receive healthcare and what kind of treatment he should receive. And what I couldn't understand in those 3 days where I had to sit and wait to get healthcare is how is it that my dad was able to make healthcare decisions for his dad, but I couldn't make my own healthcare decisions for myself and for the child that was inside me. I had no right, I had no opportunity, and neither did my healthcare team.
In addition to changing the legal standard to get the result they wanted. The other thing that stuck out for me in that decision was Justice Alito's language that Roe versus Wade, and I'll quote him here, was egregiously wrong from the start. So presumably that means the start back in 1973. Well, after that start, while Roe was egregiously wrong, Alito came before this committee, and he had the chance to tell us that he thought Roe was egregiously wrong, make that observation about that case, and instead he hid that sentiment. He said instead, Roe versus Wade is an important precedent of the Supreme Court. It was decided in 1973, so it has been on the books for a long time. It is a precedent that has been on the books for several decades. It has been challenged. It has been reaffirmed. No egregiously wrong. Everything designed to reassure us that he was not going to overturn that decision. So looking back, he looks a lot like a sleeper agent predetermined to attack Roe, who wouldn't disclose what he was up to until he had the majority that he needed to change the legal standard and destroy the legal precedent. I think it's a very unfortunate episode in the Supreme Court's history. Let me start by pointing out that there are two sides to a judge's job. One is the judicial side, adjudicating matters, and the other is administrative side, which includes the ethics part of a judge's job. You have a clue which role the judge is playing if they're wearing a robe. If they're not, it's very likely the administrative side of their work. In the administrative side of their work, where the ethics questions are handled, those determinations go to the judicial conference. That's the same body I mentioned earlier that was established by Congress and that implements the financial disclosure laws passed by Congress and the recusal laws passed by Congress. It is made up essentially entirely of lower court judges. One justice sits on it as chair, the Chief Justice. And questions about financial disclosure of the justices are sent there now. We know that because we've seen it happen. In the first round of Harlan Crow to Clarence Thomas yacht and jet free travel disclosures, back in 2011, that was sent to the Judicial Conference and to its Financial Disclosure Committee. Its Financial Disclosure Committee is composed entirely of lower court judges, circuit chief judges and district chief judges. That is who resolved the matter of that first round of gifts from Harlan Crow to Clarence Thomas. And the second round, right now, that the Judicial Conferences are reviewing was again sent to the Financial Disclosure Committee, again made up entirely of lower court judges. So the objection that lower court judges would make a determination about whether justices have complied, for instance, with financial disclosure rules, that's the present state. That's the present state. And the other question that went before them recently was this question of Justice Scalia's maneuver, you want to call it that, of reading a personal invitation from a resort owner with whom he had no personal relationship as a matter of personal hospitality. When that question went back for determination, it went back to the Judicial Conference. And it was the Judicial Conference made up of lower court judges that said, no, that doesn't fly, that is not legal, that is not what the personal hospitality disclosure rule permits. I don't know if I'm holding up a vote at this point. No, not yet. Okay, we're still waiting for people to come back from the voting. So, you know, there are a lot of canards that are flying around in all of this. The canard that lower court judges can't make decisions about the administrative side, the ethics piece of Supreme Court justices' behavior is just simply belied by the fact that it has happened exactly that way over and over and over again, and without objection. Without objection. When Justice Thomas's first round of secret yacht and jet gifts from Harlan Crow was referred to the Financial Disclosure Committee, he did not say, wait a minute, you can't send that to that body. They're all lower court judges. He went along with it. And no Supreme Court justice has ever complained about lower court judges through the Judicial Conference exercising their judgment about administrative, financial, and ethics matters. So that just ain't so. And the argument that we are up against an attack on the independent judiciary and that this violates separation of powers, again, is belied by the acts of the justices themselves. The Judicial Conference has existed for decades. The court knows it exists because the Supreme Court Chief Justice chairs it. They have never objected to that being an intrusion into separation of powers because it was established by Congress. And the financial disclosure rules that Congress established. Again, when the matter about the first round of Harlan Crow to Justice Thomas secret yacht and jet travel gifts was sent to the Judicial Conference, nobody said you can't send it there because it violates separation of powers. They didn't say you can't do it because it's lower court judges, and they didn't say you can't do it because it's separation of powers. And that's because both of those arguments are completely false. There are ways to solve this problem that work squarely within the constitutional principle of separation of powers, a principle that I revere. As one of my Republican colleagues said today, there's also the question of checks and balances, and that we have to allow power to check power. Allowing Congress the power to check abuses in the judicial branch is a long established and proven fact that the Supreme Court has for decades gone along with without complaint, even when, and perhaps particularly when, it involved justices themselves. And indeed, after the Judicial Conference said, nope, you cannot fake personal hospitality if it's a corporate venue. You cannot fake personal hospitality just because it's a personal invitation. You cannot fake personal hospitality if there's not a real and long-standing personal relationship. When they said that, they were exercising powers given to them by Congress. And there was no objection to that from the Supreme Court. Indeed, Thomas put out a rare statement saying he would abide by that. He did not say that's unconstitutional. He did not say lower judges shouldn't do that. He did not say there's a separation of powers problem here. He said, yep, I will follow that new rule. Congress can, of course, investigate how laws Congress passed are being implemented by an agency Congress created. For me, all the theatrical wailing and gnashing of teeth from these billionaires and their lawyers signals actually that there's a lot being covered up here. And that should reinforce our determination to get to the bottom of this scandal. The fundamental question here is how bad, how corrupting is the billionaire influence at the Supreme Court? How serious is the appearance of impropriety? You don't solve an appearance of impropriety problem by keeping the impropriety secret. It's still there. It is now time for sunlight, the best disinfectant. At the end of the day, the overheated objections we have heard from the billionaires assume the answer that nothing untoward or improper has transpired. But that is precisely the question we need to be investigating. To say that an investigation is outrageous and should stop because we're all innocent presumes innocence, a fact not here in evidence. Indeed, all of the abundant evidence is to the contrary, that this is part of an orchestrated scheme to influence and control our Supreme Court. Thank you, Chairman. First, let me thank my three colleagues for joining me on the floor today. A word that came up repeatedly was reverence, and I want to start with that word because I think we all do share a reverence for the institution of the United States Supreme Court. And that is what makes it so bitter to see how badly the Supreme Court is failing us now, and to see the paths that billionaire influence has led it down. It has to correct. And if it's not going to correct itself, then Congress is going to have to correct it. As Senator Blumenthal said, the problem here is that there is no ethics process for the Supreme Court. There's a perfectly good code of ethics for all of the justices and for all of the federal judges, but there's no way to enforce it for the Supreme Court. If you have a complaint about a Supreme Court justice, there's nowhere to file it. There's not even an inbox. And if there were an inbox and the complaints came through, there's nobody on the other side of the inbox to screen out the nutty ones from the legitimate ones. And once you have the pile of legitimate ones, there's no staff attorney to do the basic research into what are the facts here. And at the end of the day, when you have the facts determined and the judge or the justice has had their say, then you have the factual predicate to compare with the ethics standard and a neutral decider to decide whether or not it comports. That is the basic structure of United States due process. And the Supreme Court will not allow that for itself. That is the problem that we have. So none of the questions that deserve to be answered about all these secret gifts and about all this billionaire influence, none of them have even been asked over at the Supreme Court, let alone answered. So we have an absolute obligation to go forward with answers. And we have tried. We've asked very nicely. We've sent lists of questions. We've gone forward with the people who would know about all of this. And we've received two answers. One was that this is unconstitutional, and so we're not going to participate with you at all. You get nothing. You don't get a single answer. That, as Senator Blumenthal said, we believe to be a complete sham and a complete charade because the disclosure rules, right? We're talking about disclosure of gifts to justices. They went undisclosed. So the question is, should they have been disclosed? And there is a rule about disclosure that just happens to be a law passed by Congress. And there's a related law passed by Congress that relates to recusal. And recusal relates to gifts because if you take big enough gifts from someone, you then have to recuse yourself as a judge from their cases. And the recusal rule is also passed by Congress. So you have a disclosure law passed by Congress, and you have a recusal law passed by Congress, and you have, as Senator Blumenthal described, the Judicial Conference, which is the administrative body that oversees the administrative side of the judicial branch. And that body was also created by Congress. So the argument that is being made to us is that Congress has no authority to oversee how an agency Congress created is implementing laws Congress passed. That argument is on its face preposterous. And that in turn suggests that there is a lot to look at when we get a chance to look under the hood of all this mischief. And they really don't want us to see it, and they're going to manufacture completely preposterous arguments just to try to throw us off the trail. Another recipient of our questions said, okay, it's unconstitutional, but I'll offer you a few things. You know, in good faith, I'll offer you a few things. But you can only go back 5 years. Well, we happen to know with respect to this billionaire that they were giving gifts to justices way more than 5 years ago. So they're not even allowing us to ask into the known gift-giving conduct between the billionaire and the justice, which, by the way, was undisclosed at the time. So the 5-year rule is just nonsensical, just picked out of the air, picked actually out of a criminal statute, as if that had a bearing on a congressional investigation. Then they said, we'll only give you the documents that you already have. For everything else, we'll just give our lawyer's narrative about what took place. Well, anybody who's ever tried a case knows perfectly well that if you rely on the other side's lawyer's narrative, you're getting no place. Discovery means you see the documents. You do your real homework like lawyers do. So for one lawyer to suggest to another, no, we're not going to show you the documents. We have them, but we're not going to show them to you. We're just going to give you our narrative about them. There isn't a lawyer in this country who would accept that as a condition in discovery in a case. And the third one is that once we've answered your first round of questions and given you our phony baloney narrative for the 5 years that is all we'll let you inquire about, no more questions. You waive your right to ask us any more questions forever. Again, there's not a lawyer in the country who would accept that as a condition of a discovery order. You get to ask the second question. One and done is not a thing when you're doing an investigation. So all of these theoretical accommodations that were offered were just completely fake. We cannot proceed that way, not with any kind of professionalism and not with any kind of ability to get to the truth, which is at the end of the day what we really need to do here. I will conclude by going back to where I started. The reason that we need to follow this process of getting subpoenas so we get answers to our questions is because of two failures. One, the failure of the Supreme Court to even ask these questions itself. If there were a viable process going forward using these basic due process investigation standards that everybody in government has to face for ethics except these 9 justices, we wouldn't need to do this. But the Supreme Court won't allow questions to be asked about itself. So we can't go to them for a proper investigation. They refuse to do it. And when we asked the participants in this gift scheme what they were up to, they told us, as the ranking member of the Judiciary Committee, I think rather artfully summarized, to go pound sand. Well, when Congress has a legitimate inquiry into how an agency that it created is implementing statutes that it passed, go pound sand is not a legitimate answer. So the next step is to move to authorize these subpoenas, and we are going to do that. This business of the court not answering obvious questions is really a problem. There is no federal judge in the country who is receiving multi-$100,000 vacation gifts, who is getting huge $500,000 checks sent into a spouse's small private company out of which she takes money. This behavior of free private jet travel at beck and call, it seems, nobody else does that. It's not okay, but looking at it to find out what actually took place and why and when is a basic responsibility of the judiciary. In any other court, these claims, these charges, these circumstances would be properly investigated. We'd know the facts, and we're entitled to know the facts. The last is that in the context of our investigation, one of these lawyers made up what I consider to be a sham argument that we can't ask any questions because it's unconstitutional. I've addressed that. It's a congressionally established entity applying congressionally established laws. Yes, we do get to inquire about that kind of a job. Because perhaps that argument is so weak, so sham, that lawyer actually recruited a Supreme Court justice to go into the editorial page of the Wall Street Journal and offer an extrajudicial opinion, not an opinion of the court, just his own personal opinion, that we had no business investigating. That violates a ton of stuff. That violates the rule that they're not supposed to offer opinions on matters that might come before the court. That violates the rule that you shouldn't be engaging as a justice in an ongoing dispute, sort of like a de facto expert witness for a party in an ongoing dispute. In this case, the dispute is over access to information. The lawyer's client in that is one of the people involved in this scheme, Leonard Leo. And Leonard Leo has a personal relationship also with Justice Alito. He's described as his friend. None of that is disclosed. He just offers this opinion on behalf of the lawyer for his friend. And at the end of the day, the inquiry looks at free gifts, undisclosed, received by Justice Alito. At the end of the day, the lawyer for Leonard Leo was able to recruit a member of the Supreme Court, Justice Alito, to offer a private, I should say a public opinion, but a non-official opinion, a personal opinion in the Wall Street Journal editorial page to prop up the argument that says we can't look into gifts that Leonard Leo, the client, organized for Justice Alito, the recipient. That is a tangled mess of ethics violations. And nobody can look at that. Nobody will look at that. That can't be. So with the court looking at none of this scandalous behavior, it is entirely incumbent upon the Congress to do its job and get to the bottom of what went on. And that is what, under the leadership and guidance of our Judiciary Chairman, Chairman Dick Durbin, we will do. With that, I yield the floor. This is driven by climate change. Let's be clear about that. We've had 14 named storms so far in the 2023 hurricane season. If you look back at last year, weather-related damage in the United States topped 165 billion. We've had testimony in my budget committee that in OMB, climate change will cost the federal budget $2 trillion per year. We cannot address this piecemeal, and we cannot address it only by providing disaster relief and not doing anything useful to head off these risks. Some of these are what economists call systemic risks. Systemic doesn't sound like it's a very big word, but what it means is the risk cascades out of the area where the economic harm is taking place to trash the whole economy. Just the way the 2008 mortgage meltdown didn't just trash the banks that had the bad mortgages, it took down the whole U.S. economy. That's predicted for coastal property value crash. That's predicted for a wildfire uninsurability crash. That's predicted for a carbon bubble crash. And the insurance meltdown has already begun in Florida, in Louisiana, and in Texas. So the warning signs of another 2008 scale financial crisis are already flashing red, and behind those immediate warning signs looms the collapse of Earth's basic natural operating systems that science has predicted for decades and with real precision. we need to do a lot more than just clean up. We do need to clean up the disasters, but we also need to get the pre-disaster preparation and resources in, because we know this is coming and we know it's getting worse, and we absolutely need to head off the root cause of all of this, which is fossil fuel emissions, choking our atmosphere with greenhouse gases, heating up the earth, and causing us to spin out from basic conditions of habitability of the earth that have existed for tens of thousands of years. So what we should do is pass the continuing resolution with full funding for the President's supplemental request for FEMA's disaster relief fund, for the Department of Agriculture firefighter money, for the Department of Interior firefighter money. And while we're at it, because President Zelensky was here today, I'll also add that it's really important to continue to support Ukraine. So for those reasons, I will object.